Hello, so this is Module 11 for our course IT248, which is our graduate course for Information Privacy, Regulation, and Policy. And this module is based mostly on Chapter 11 for the book that's required reading for this class. So this particular module covers the role of contracts, and this really the focus here is with respect to privacy and non-repudiation. Non-repudiation means you can't deny that you signed the contract, really in a handwritten way, or the focus of this class, an electronic contract. So let's move on. I want to point out a couple of things on this high-level introduction to this module, and that is the Uniform Electronic Transaction Act, UETA, which was passed in 1999. And this act really removed some technical barriers or legal barriers to electronic commerce in terms of validating contracts online. So it clarified the legality and the specificity of how electronic contracts would function. And I also want to point out towards the bottom here, something you've probably all been familiar with, EULAs, end user license agreements. We're going to talk a little bit about that. These are the contracts that we sign when we click, we accept, and we unless we read 50 pages of terms and conditions, we really don't know what we're accepting, and it's a bit of a privacy issue because we don't really know a lot about what's happening to our data with these EULAs. General contracting principles. Before we get in any deeper with any specificity, just be aware that there's the contracts are governed by common law and by actual law, coded law. And there's a uniform common code that was put together through sort of like this is what the accountants have GAAP, General Accounting Principles. This is sort of the same thing for lawyers. There's the Uniform Laws organization, uniformlaws.org. You can see here there's the website for it. It's a nonprofit organization that provides clarity about interpretation of laws. And they have provided some clarity regarding electronic contracts as well. So I just want to mention that. Contract forms. They can be oral. Oral contracts that are not written down, they're still enforceable. As long as there's a reciprocal exchange of value, it's a contract. Of course, written contracts are better. There's some specificity, clarity, terms and conditions are more clear. But verbal contracts, as we'll see an interesting story later on in this module, an interesting story about a TV commercial that became a contract. Kind of interesting. Capacity to contract. You have to be 18 years old, mentally competent, not intoxicated. These are the basic fundamentals of any contract that makes the contract enforceable by being over 18 and not having any other issues mentally. Some contracts are not enforceable. If the contracts reduce commercial competition somehow, they're maybe in violation of the racketeering, the RICO laws. If you're committing a crime through that contract, unfairly burdensome to one party could be considered not enforceable in a court of law, or if it discriminates against race, religion, etc. So what is a contract? What are the important pieces to it? It must contain terms that are detailed enough that the person who's offering the contract, it's understandable to the other party. And the offer remains open until it's accepted by the other party, rejected, or the party that originated the contract could retract it and say, well, I've changed my mind. I'm not even offering this anymore. So that's a possibility too. That's a legal possibility. Form of acceptance. What does it mean to accept a contract? Well, an offer is accepted when the offeree, the person offering the contract, agrees to the offer, the person receiving the contract agrees to the offeror's terms, the person who submitted and originated the contract. Kind of odd terminology. So basically it's countersigned. I submit a contract to you, you countersign it, I've signed it, I send it to you, you countersign it, you sign it as well, and now it's an actual offer. And as far as somebody considering an offer that's a valid offer for someone to accept or not, there's this mailbox rule that says once it's mailed, once it's dispatched, the person now has a valid contract that can be countersigned and become valid once the recipient takes it and signs it. The court has ruled emails are the same. I send you an email offering a contract. Once it leaves my system to your system, at that point, it's a valid open contract for someone to sign, countersign, and make valid. So during the contracting process, there has to be a meeting of the minds that both parties have an understanding of what the transaction is regarding the transactions around this contract. What are the terms, whether it's written or whether it's not written. And the proof of this is there's a really interesting video. You see here on the bottom left-hand side the link. You can get the link from the PDF or just type it in carefully, but you're probably better off copying these out of the PDF and posting it to watch it. But Pepsi some years ago had offered a Harrier fighter jet, as you can see here on the right, for a certain number of Pepsi points, and didn't realize that there is a possibility of somebody trying to buy the Pepsi points and not purchasing all that Pepsi. And it turned out to be a legal contract, and it's interesting. Watch the 2-minute video, and it really proves the point that you don't need to have a written contract. This was an offer that was put out there, as an ad. Wasn't mailed and it wasn't emailed, but it was offered through television, and the court ruled that this is a valid transaction or offer. There are a number of outcomes that can happen when a contract is breached. When someone does not fulfill their part of the bargain, their part of the contract, that's considered a breached contract. The contract's in breach. And there are a number of compensatory results that can happen. The first one is payment for a breach of a contract. So there could be terms in the contract pre-written as well for certain things that aren't done. So like in an IT contract, you might have, you expect 99.9% uptime, and your cloud server is not up 99% of the time. That's a breach of the contract, and there could be some, some payment for that. And it could be, you really should be put, whatever the terms are in the contract, the deliverables, the things that the offering party is supposed to deliver to the recipient, there should be, you should always try to have some sort of financial penalty. And the penalty could be executed by not paying your maintenance contract fees, or part of your maintenance contract fees. So that's the first thing that could happen. The other thing that could happen is something that's more, could be more consequential. So if your system is not up the way it was guaranteed to be up by the vendor, and you couldn't have certain sales, or you had brand damage, or sales didn't happen, your system was down and you lost sales because the system was down, or you had some brand damage, you could have other consequential damages. And there's also liquidating damages predetermined in the contract. If you want to completely liquidate the contract, what happens? You could put that in the contract up front. The contract should say, if one of the parties agree, or if both parties agree, you have to work out those terms. What are the liquidating? What's the liquidating damages? What do you pay? Who gets what amount of money for terminating the contract? And then there's nominal damages, where there may be nominal payment for breach without any real suffering damage, something minor, but there could be some damages in terms of some financial payment. So there are two key terms on this slide. One is repudiation, and repudiation has to do with somebody saying, I never offered that contract, or I never sent you that email, or I was hacked. You have to really sort of prove that you really didn't send that contract. You really didn't make the offer somehow. I put here on the right in red, there are internet cryptography, encryption technologies to ensure repudiation. So when you send the contract out electronically for an e-signature, an electronic contract, it's really very difficult to repudiate and say, I didn't send it or I didn't mean it. So it's very hard to repudiate a contract. And repudiation is when a party denies the existence of the contract. It says it never happened somehow. Now, the flip side of that is a person who's the non-repudiating party. So if you have a contract with a vendor, and the vendor says, I'm repudiating the contract, it doesn't really exist, I didn't mean to offer it, or whatever, tries to withdraw it somehow, even though it was mailed or emailed, which means it's a valid offer, the person, the non-repudiating party could say, okay, I agree, and the whole contract's off. Or they could wait to see if the vendor provides the services or products with which they promised in the contract. Or you could sue. You could sue the party. So that's the concept of repudiation, saying the contract doesn't really exist in some way. And the things that you could do if that happens to you in terms of you being the non-repudiating party, you could sue, you could agree to it and say the whole deal is off, or you could wait and try to pressure in some ways to get the vendor to deliver and keep the contract intact. And as I say here on slide 16, we'll see a little bit more details on how electronic contracts work over the internet, electronic contracts that are encrypted. Very hard for either party to repudiate that it was sent or that it was signed. Because really, when the person sends the contract out, when they're making the offer, they're signing it, and then it goes out in the mail or through email or through electronically over the internet. So it's hard to really pull that back. And if both parties have signed it, neither party can easily repudiate and deny the fact that the contract exists. Now, of course, internet contracts or online contracts, they create some difficulties and some problems, which we'll talk about. But the very first column here speaks to the underlying rules, the underlying assumptions. They're the same, whether it's electronic or whether it's paper or whether it's verbal. The underlying concepts are the same. There's no difference there. Where the problem comes across is this middle column here. When the parties are in different states, and states have different rules about liability in particular, or whatever other issues with force majeure, acts of God, or some other kind of problem that may come up, the states sometimes have different rules. And if you look on the right-hand side, the right-hand column here, it's unlikely, in many cases, that the two contracting parties are in the same state. And I've seen this happen many times where you have the lawyers try to sort of battle it out, and no one wants to sign the electronic online contract until terms are changed and it was resent. Or if it's a paper contract, that happens as well. Having two different states and two different laws governing liability makes the online contracting a little bit more complicated for that reason. So it's not as automatic and not as easy. Paper contracts, you have the difficulty of a Word document coming over, someone makes changes, they send the Word document back, and the two lawyers in different states are sort of arguing over which state's liability laws take control. When it's online, it's more difficult because now you have an online, it's not as, you're sort of working back the way it was paper. When you have two different states, there's no advantage to the online contract anymore. If there's disagreement about the state laws, so if there's disagreement about the state laws in an online contract, there's no benefit to being online anymore, because now there's going to be debates and conversations and resubmissions the way you would have with a paper contract. So the point is, it's not always as easy as one would think because it's online, and the difficulty most of the time comes in when there are different state laws involved between the two parties. As we mentioned in the very first slide, the Uniform Electronic Transaction Act passed in 1999. That really removed some barriers to electronic signatures and electronic contracts, I should say. It really covers more than the signatures, electronic contracts in general. So there was some ambiguity about electronic contracts when the world was switching from being exclusively reliant on paper to electronic contracts. This law was passed in 1999. Oddly, only 47 states, and that's current even today in 2023, only 47 states have adopted this law. But on the other hand, there was another federal law, the E-Signature Act, or sometimes called the E-Sign Act of 2000, and that specifically validates electronic signatures throughout the whole country. So the laws are different. One, the UETA Act covers electronic contracts and removes some ambiguity, and most states have elected to subscribe to UETA. But the E-Sign Act is federal, and that affects every state, but that's focusing specifically only on electronic signatures, that your personal electronic signature is valid over the internet through an electronic signature process. We're going to look at electronic signature process a few slides deeper into this module about how that actually works and how the encryption works and how that takes effect. So jurisdiction is important. The state you're in some cases, different nations obviously have different rules. And this is important for online contracts because states do have differing liability laws. As mentioned earlier in slide 12, states have different liability laws, and sometimes when you're trying to execute an online contract and the lawyers in different states disagree on which liability law takes effect here. But in addition to that, states just have different terms and different understanding of online contracts as well. So depending on the state you're in, depending on the country you're in, not only do you have differing liability laws, which is a problem regardless of what kind of contract it is, paper or electronic, but there's also different understandings in terms regarding electronic contracts. And there are 3 states that don't even follow UETA, as we mentioned in the previous slide. So that's not completely been subscribed to by every state in the United States. So what are the differences in online contracting among the states? You could have differences in what the legal age is for an e-signer, whether it's 18 or 21 or some other number. You're going to have differences in terms of understanding if email is valid, is as valid as any other electronic contract that happens through. There are lots of vendors now like Adobe and DocuSign. There are lots of companies that handle specifically electronic contracts, and I'm going to show you on the next slide how that technology works a bit. I've added some information about that. So there's differing opinions in different states about what is a valid e-contract. Emails may not be considered valid in every state, and you've got to use the right technology, and that could differ too, depending on the state. But I think at this point, most states probably accept. At least I haven't run into issues, and I've done contracts in at least about a dozen different states. I haven't run into a problem with anyone having a problem with DocuSign or Adobe or one of the large national carriers as far as technology goes. So let's look at the next slide and see how this actually works. So this slide speaks to there's legal reverse logic. It's opposite logic, let's say. So on a handwritten signature, you have a handwritten signature. There's no assumption when you see a handwritten signature that it's authentic. The burden of proof is on the person who signed it to prove that it's his or her signature. With electronic signature, I say it's legal reverse logic, regarding these assumptions, because with the electronic signature, the assumption is the electronic signature is authentic. So handwritten signature, the assumption is it's not necessarily authentic. The signer has to prove it's his or her signature. With an e-signature, the assumption is the reverse. It's assumed that it is authentic. So why is that the case? The reason that's the case is with all e-commerce, whether it's you're logging on to the bank to do banking business, whether you're shopping on Amazon or Walmart electronically, these web servers have to have a security certificate from a certificate authority. Certificate authority could be IBM, could be Symantec. There are dozens of companies that provide security certificates. So what does that mean to have a security certificate on your website? It means that you have been given from this third party, IBM, Symantec, or whoever, a set of encryption and decryption keys. And it also proves that these keys belong to you, the certificate, to your website. So so when you see that HTTPS, that little S is telling you that there's a security certificate involved, a third party's provided assurance that this is the right website that owns these keys, and these keys provided from a third party doing the encryption and decryption. So what happens is if I'm sending you a contract, I'm going to have a private key. Now the private key and the public key, if you notice here in the bottom, the security certificate is provided from a certificate authority, some IBM or Symantec or someone like that. They're going to provide a private key and a public key. See here, bottom, private key is green, public key is blue. They're provided together. They're mathematically connected. They work together, but they're different keys. They're different keys. So the sender of the contract has a private key. So if I'm sending you a contract, I use my private key from my security certificate, and I encrypt. And all this happens under the covers. You don't see this happening, but all the right protocols and the website are kicking these things off, these algorithms. So there's an algorithm to do encryption. It's using a private key to do the encryption. Nobody has the private key but me, because it's my website. It's my account on Adobe or DocuSign. It's my account. I have my own private key. I encrypt it. I send it over the internet. You get it. You download my public key. Anybody can have my public key, and that public key allows you to decrypt it. So your public key is my public key. I have a private and public key. Only I have the private key. If my private key is lost or hacked, I have to get new keys. Because then anybody could pretend they're me. So I have a private key that does the encryption. I send you my contract. You get the public key, and you're allowed to decrypt it with that public key. And that's how this whole PKI, public key infrastructure, PKI, public key infrastructure works. And it works similarly, a little bit different with e-commerce, with web, like Amazon, if you're shopping on Amazon or Walmart. Not to confuse you here, but later on we'll go into how that works differently. Bottom line is the way it works differently is the initiation is the shopper, the person going on Amazon, gets the public key first. and the encryption is initiated with the public key, and then Amazon or Walmart or the bank uses the private key to decrypt. So it's still using a private public key, but the way it's initiated is differently. With a e-signature, the private key initiates the contract, and the public key does the de-encryption for the other party. So it's just the reverse in terms of in a e-signature, the green key.
Okay, I found this on the web for e-signature.
Oh my goodness!
The
Hold
private
on.
key initiate the contract, and the public key.
Sorry, I muted that my Amazon, but it seems like either the Apple TV or something else was. I got to figure out what was talking. Maybe it was coming from another room. So where was I? So that the whole concept of this PKI, the public key infrastructure, is used for e-signatures and e-commerce. Very similarly, but the initiator is the public key when you're shopping. When you're doing an electronic signature, the private key is the initiator, and that's about how all this works. All right, so here comes a gray area, a dilemma. Okay, I sign my signature with my finger on an iPad. Now, is this a handwritten, just an image? It's a handwritten image of my signature, or is it an e-signature? Right? It seems to be handwritten if it's just an image, but if there's a transaction with an e-transaction with, as we mentioned earlier, encryption using a public-private key, right? Then it's really sort of you would think it's more like an electronic signature, right? So if I'm just signing it and it becomes a document, an image, I should say, just an image, it's probably a handwritten signature. But if I'm using the public-private key infrastructure and it's actually getting encrypted and decrypted, it seems to have more, more of a authenticity and harder for anyone to repudiate. You might think I would think at that point it's an e-signature. Actually, it depends on the state or the country you're in. So the laws are vague and different from state to state when it comes to the determination of this. But I would think most states would look at an image as paper or as an image, signing my name on it to an image. I would think that'd be handwritten. But if there's a public key infrastructure, public-private key infrastructure being involved, I would think that'd be obviously should be considered electronic. But again, you really have to look at the laws in each state to be certain. So the internet and these electronic contracts over the internet has created some complexity as well. Really, not much complexities. I guess I should say there are more advantages to the vendor now, particularly software vendors and hardware vendors or vendors that are providing services. And we're somewhat disadvantaged as a customer because we click on this agree. There's no negotiation. You can't go back and forth. When you're updating your software on a browser or on your phone or whatever application software you're upgrading, you either agree or you don't agree. You either have the upgrade or you don't have the upgrade. Or you have the app or you don't have the app. There's really no negotiation. So we're at a disadvantage as a consumer. So these are called EULAs, end user license agreements. It protects the software owner's copyright. It specifies how the consumers may use the software. It's all coming from the provider. It's all coming from the vendor, I should say, the vendor who's controlling everything here. So we are at a disadvantage, and I really do think there needs to be a law. We'll maybe talk about this later in this module. We need to have a law that rather than try to read 30 or 40 or 50 pages, which no one can do every time you upgrade something, there really should be a page or two that has the most salient, the most important information to the consumer. Who owns the data? Is it shared? How is it shared? Can you delete your data? Maybe a handful of things you can probably put on one page. And all the other T's and C's, the terms and conditions and the legalese that go on for 40, 50 pages, I'm less concerned about. But I'm more concerned about, well, who has my data? Do I own my data? What's my privacy? Do I have privacy? What's my expectation of privacy? So these EULAs do need there does need to be some legislation to help this. Years ago, you had shrink wrap, software that came in boxes. And, sometimes you couldn't read the license till you open the box. And then you read the license inside. Now, if you wanted to return it, you probably could if you pushed it, because most courts would say that, with these class action suits would say that this class action suit is going to win because you couldn't give the person an opportunity to read the contract without opening the shrink wrap. And now you're saying you can't return it. Well, you should be able to return it. So if the license and the terms and conditions are on the box under the shrink wrap and you can read it, well, that's more fair. But if you open the box to read the contract and then you can't return it, it does seem a little bit unfair, and courts have not been happy with that arrangement. And shrink wrap's pretty much gone away today for the most part anyway. Everyone gets a software downloaded over the internet. So as I said in the earliest slide, the just previous slide, we talked about shrink wrap, and that's pretty much gone away. There really is shrink wrap doesn't really exist. Everyone downloads. But then you have click wrap. You click accept. You click agree. And these are boilerplate contracts. You can't change them, no negotiation, and no one can read it. You know, no one. I mean, you can read it, but you probably need a lawyer next to you to read these things. It's a problem. And then there's also a browser app that you get on a browser, right? You're on a website, and who reads these? There's really, again, no affirmative action. Sometimes you really have some ability to control some of the privacy settings or the cookie settings, but that's called browser app. Browser
You'll
app.
need to unlock your iPad first.
Sorry. That's called browser app. Now, I put a little here, a comment I made in the earlier slide. You know, we really need some sort of legislation because we have no idea about our privacy. You know, who's using our data? Where does it go? Who owns it? There's no negotiation. If there are calculations, do we own the calculation? Does the vendor own the calculation? There probably needs to be some law that says that one page describes these salient privacy issues and data issues that a consumer can read realistically, because it's not realistic that we could read all of these multitude of pages every time we upgrade software or download software or a new app, and half of the language is so in legal jargon that we may not even understand a lot of what we're reading. This is essentially the same statement. We need some legislation to really help the clarity, for the consumer. And as I said earlier, it benefits the owner and the vendor. It doesn't benefit us. I mean, they're protected by these boilerplate contracts where we can't negotiate. We don't even really understand most of what we're agreeing to. So we need legislation for this really to protect our privacy. This is a nice slide because it sort of shows all of the different categories of areas within the browser wrap and the click wrap, the EULAs that we just say I agree and click yes. You know, how is the data used? What are the kind of fees might possibly be involved? You know, what are the updates? Termination and breach. How do you stop this? Can you delete the data they have of you? What are the warranties? Can your data be used for advertising? All these boilerplate terms have no real. There's really no negotiation on the part of the consumer, and there's really no way to criticize or change or negotiate what's happening. You know, what you're agreeing to. We've all become much more sensitive to our privacy and security with all of these internet products that we have. And there are two laws you should be aware of, and I believe these are, definitely be on your final exam. Gramm-Leach-Bliley and HIPAA. So Gramm-Leach-Bliley, and we talked about this earlier in the semester, even before the midterm, that really provides for protection for our financial data, our financial information. So any fiduciary, a bank, an insurance company, a broker, any company that's has our money, or has an account, is getting premium payments for insurance, or is has our investments, has to keep that private, that information private. HIPAA does something similar for healthcare, so that that providers have to protect and secure our healthcare information. If you're a contractor, if we start a consulting company for Northwell, we have to sign a BAA, a Business Associates Agreement. And the Business Associates Agreement makes us responsible as a contractor if we're seeing patient information from from Northwell, we're seeing patient information from Northwell, we have to follow the HIPAA regulations. And we're responsible. You know, in the past, before these BAA agreements existed, it wasn't clear who was responsible if there was a breach. Would it be Northwell responsible for breach of data, or would it be the vendor, the subcontractor? So now the consultant, the subcontractor, working for a large health system like Northwell, has to sign a BAA, Business Associates Agreement, making them liable and making them aware that they have to follow the HIPAA protection, privacy protections. And there should also be not just data privacy, but security understanding and security terms. When you sign a contract, when two companies are sharing information and they're sending files back and forth, there should not only be a BAA, but there should be a security agreement about how the data is going to be encrypted, whether it's at rest or whether it's in process or whether it's in transit. All the files that are being, file transfers back and forth. How are they going to be encrypted and secured? What kind of password strength and password complexity? So that needs to be. There's no real legislation about exactly how to do that, but since there is legislation about you having to protect the data and keep it private, whether it's financial data under Gramm-Leach-Bliley or whether it's healthcare data under HIPAA, you are required to keep that private. There's no a lot of specificity around the way in which you do encryption. There is some law now with high tech that speaks to encryption, but the kind of protocol you use and the kind of algorithms you use is really up to you. So there should be something about who owns the data, who owns calculations, when are things deleted, when the contract expires. So you should have some security terms and understandings in the contract as well, not just privacy. Cloud computing. So much processing storage is done in the clouds now. An entity's data is not just stored on premises in a physical computing structure, in a physical computing center or a data center. So there are concerns about cloud computing. And we're going to talk on the left-hand side of this in red. You see infrastructure as a service, IaaS, PaaS, SaaS. We're going to talk about that a little bit more, different flavors of how you could use the cloud, how companies use the cloud. And we as individuals use at least software as a service, like you subscribe to email with Gmail or Yahoo Mail. That's software as a service. We'll go through this in more detail later on, but companies will use all three of these depending on their needs, all three of these different flavors of cloud computing, IaaS, PaaS, and SaaS. But there are some concerns. There's loss of control of the data. You may not know exactly where your data is even being stored. You may know it's on the East Coast or the West Coast, not more than that. There's a potential for loss of privacy, depending on the vendor and how secure, or if they have subcontractors. We may trust a big company like IBM or Google, data, Google Drive or Apple. But who are their subcontractors? How well are they vetted? These large companies probably vet them well, but you're only as strong as the weakest link in your chain, right? So you may have a great vendor, but the subcontractor might have some vulnerabilities or create vulnerabilities. So there's a considerable concern that there could be privacy loss of data, dependency, very dependent on that third party. There are companies that have been put out of business. There's a whole sort of political backstory to an app called Parler that was shut off, completely put out of business by Amazon shutting their servers down. You're very dependent, and if you get caught in the middle of a political debate like that, you're out of business. They've sort of come back. This company that completely they haven't liquidated, but they were the biggest competitor for Twitter, and now they're hardly even heard of because they were really shut down. And there's a potential for any sort of technology problem, downage, not just a hack, but outages. And again, you have no control over their third parties. You're contracting with a vendor. They're contracting with sub-vendors who may contract with other sub-vendors who may not be even in this country. They may not even be in the country. And you have to rely on that chain of control, that chain of custody for your data. And, there are some, you have to make certain assumptions, but these are the risks that you have to go into, eyes wide open, understanding what the risks are. We talked a little bit about this earlier when I said that you have to be concerned with, privacy, obviously, but also security contracts. Security agreements between companies that are sharing files, sharing information. Let's start at the top here. How data is defined. Is calculated data or some sort of data that's augmented to your data? Is that still data you own, or who owns that data? Does the vendor own it? How is it used? How is it protected? Is the vendor meeting all the legal and regulatory requirements? The fourth bullet here. So there are things in the contract that you want to have. If you're a company like Northwell and you're exchanging files with consulting companies or partners or companies that may not be really your subsidiaries but partners, what kind of encryption controls? What are the encryption protocols for data in transit, data at rest? Who owns the data, as I said earlier, with calculations or algorithms? What happens to the data when the contract ends? These are all the things you need to have in a contract. And again, a lot of this isn't really required by the law, but you'd be foolish not to have a security contract. You already have lots of privacy laws that touch upon certain aspects of security, like you have to have encryption, but it may not say more than that. But there's a lot of details about what happens to data when you're sharing data with a partner that's not a company you own. So the security, the terms of the security contract with the companies you're partnering with or other consulting companies you're working with, you need to have these kinds of specificities, this kind of specificity in those contracts. So here's an interesting case that involves the email rule that says an email contract is a contract, an email agreement. So back in, I don't know what the year this was, but I think this was some time ago. There was a Mattel employee named Stuart Lamley, and he sent an agreement for a license for a new game via email. So he told Mattel as an employee, he's sending an agreement that he wants to license, a new game that he came up with. Mattel took it, ignored his basically the agreement he sent in the mail. A court agreed with Stuart Lamley and said, no, that's a contract that Mattel should have honored, even though it was sent through the mail. That's legitimate based on the mailbox rule.
I found this on the web for a contract that Mattel should have honored.
So the court ruled that he could have a trial, that Mr. Stuart Lamley could have a trial. I guess Mattel realized that they weren't in good standing, and they just settled out of court. So that whole concept of a mailbox rule, whether it's email or sent in the mail, once it goes out, it's an agreement. The Mattel employee sent the agreement to license a new game, and via email, but it was later reneged. I suppose there was a reply back. I don't know the details of this case, but it sounds like Mattel said, yes, we were in receipt of your contract. And they seem to imply some agreement. And that mailbox rule, whether it's email or mail, constitutes a legal contract. So we've finished this module. I hope you found some of it interesting, at least. And I apologize. I have 3 different devices in my office, and these devices kept misunderstanding my comments, thinking I was addressing them. First, I unplugged my my Alexa. And then I still kept hearing sounds, so I unplugged my Apple TV. And then I realized that under some papers I had an iPad, and the iPad's microphone was turned on. So I've had 3 different ways I was interrupted. So I apologize for a couple of those. You may not notice some of it, but that was my situation. And I'll make sure things are unplugged or put into different rooms or put underwater. At any rate, I hope you enjoyed the presentation. And I'll be creating another one for module 12 next.